We're going to get started in a little bit. Welcome for those tuning in from Spotify, Apple Podcasts, YouTube. This is the Danso Pitch. We're going to get in a little bit. We're just going to let you guys rock out. Get situated. We got great content for you today. Let's go. A lot of y'all don't know this beat. Maybe a lot of y'all may know this beat. This beat been out for a minute. Resample like crazy. One of the hardest beats I've ever heard. All right, guys. Welcome to episode 47 of the Danso Pitch. I am your host, Charles Danso. I want to welcome again for those tuning in from Spotify, Apple Podcasts, as well as our YouTube viewers. This is the Danso Pitch. You can follow us on any of the platforms mentioned. Again, that's Spotify, Apple Podcasts, and YouTube at the Danso Pitch, as well as follow us on Instagram for exclusive updates like today's episodes, past episodes, and future episodes. That's at the Danso Pitch. That's DANSO Pitch. Let's get started, guys. In this episode, what I want to discuss in particular is discussing trademarking your brand, trademarking your business, understanding what exactly can be trademarked, what exactly can't be trademarked, and how do you actually register a trademark, and how long a trademark is actually good for. We're going to cover all those topics and just kind of answer a few questions that's been kind of floating out there in terms of how a trademark is actually supposed to be registered and many more. So let's get started. I hope you guys have a pen and paper because it definitely have a lot of valuable information that I want to share today. So I definitely hope that you guys definitely take the information that I share and kind of just utilize that for your business, any brands, products that you guys, services you guys are trying to do in the near future. So let's give a quick dictionary definition of what exactly a trademark is. A trademark can be any word, phrase, symbol, design, or a combination of these things that identifies your goods or services. It's basically how customers recognize you in the marketplace and distinguish you from your competitors. So what does that basically mean? Look at the most famous brands in the world: Nike, Apple, Amazon, Walmart, Coca-Cola, Pepsi, so many more. All these brands, all these products and services that these brands kind of bring out are all trademarked under the company name. So what does that basically mean? Example, the iPhone for Apple. Example, the Coca-Cola soda, any chips, any type of Gatorade for Pepsi, all of that is trademarked through the brands. Even for my sneakerheads, if you have the Jordan brand, that's trademarked under Nike. As for those that don't know, Nike is the parent or the main entity under the Jordan brand, I should say. So again, all these companies and brands are all trademarked, and that is basically what the definition kind of mentioned. Just a few key notes for you guys. Again, a trademark identifies the source of your goods and services. I kind of just mentioned that. It provides legal protection against your brand. That basically means that, again, for the examples that I utilize, I'm going to stay with the Jordan brand. This is where sneaker or trademark infringement comes into place. That means that people that try to that basically copy somebody without the permission of the person that owns the trademark, this person is liable to damages. So what does that basically mean? For the audience listening, if you guys have been following, social media, this is months back. Lil Nas X came out with a shoe design similar to the design scheme of the Nike shoe, a Nike shoe that came out. Lil Nas X, I believe he had a few people design a shoe for him, but it was quite similar to the Nike shoe that Nike owns. So Nike actually went through a lawsuit with Lil Nas X representation and actually I think they were awarded some damages as a result. This is just one of many fights that a lot of people, go through. Even the Apple brand, Apple Inc., a lot of people that may not know Apple actually originally the name was taken, I think, through this band. I don't know if, I want to say is the Beatles, I believe, one of the members of the Beatles or the Rolling Stones. I will double check that. But I believe one of them actually, it might have been like Paul McCartney or somebody, I forget, that basically had a company similar to the name that Apple uses right now. So it became a whole fight. This was like many years ago, where Apple actually had to go basically, Tim Cook and his team had to basically, not even Tim Cook, Steve Jobs at that time actually had to go kind of battle it out with the representation of the people that already were using the Apple name. I think it became a whole issue, and then eventually Apple, I think, actually won out, or they basically were able to purchase, I think, the brand name of Apple. I'll get into what that means in a little bit. But again, these are all examples of what could happen if you copy a name or similar design scheme of a company that's trademarked. So what exactly can trademarks actually protect? For the audience listening, trademarks can protect names, designs, sounds, imagery. So imagery is basically logo, design patterns, colors. You can actually trademark. I'll get more into that right now. So what does that basically mean? That means that if you guys ever see the design for UPS, the color that they use, brown, FedEx, blue and red, UPS, blue and red, so many more, even just Coca-Cola, red, the red, white interior, all of that is actually trademarked along with the name of the companies that I just mentioned. Now, the reason why someone may want to basically trademark a color is because that at times can distinguish the company from other companies in the similar scope. So what does that mean? Example, Coca-Cola and Pepsi, both are soda distributors as well as snack distributors. So in order for a company not to copy basically the look of the logo of Coca-Cola or Pepsi, Coca-Cola and Pepsi actually had trademarked their colors, as well as UPS, because UPS is obviously in delivery. So they're going against so many competitors, even newer competitors like Amazon and Walmart now. So they originally, when they started, trademarked their colors within their logos and just the company brand overall in UPS. That's something to kind of note as well. So again, FedEx, UPS, Coca-Cola, Pepsi, these are all, and many others that actually trademark their colors as well as their names. So now I want to get into how you actually can own a trademark and have a registered trademark. You actually become a trademark owner as soon as you start using your trademark with your goods and services. So what does that actually mean? That means that once you actually start a business, for the audience listening, you start some type of corporation, you technically actually do have your company trademarked. But there's more. The reason why that the company actually would be trademarked is because you actually built a company that's an LLC, a corporation LP, an Inc., a government nonprofit that's a 501c, 503. These are just how you register your company. So that basically means that the reason why your company would be technically considered trademarked is because of the fact that you actually have a business registered in terms of the business name. I would hope so anyway. You got it registered when you wanted to start your business, and you're actually operating your business. That means that you're actually looking to other distribute goods and services or already have started. You may have employees. You may start events, any type of revenue coming in and out. So technically, the government or the entities, the higher entities actually consider that a company that's trademarked. Now, the only difference is you only establish rights in your trademark by actually using it, as I mentioned. But those rights are very limited, like I also mentioned before. And they only apply to the geographic area in which you're providing your goods and services. Example, if you start your company and you don't actually register your company with the USPTO. That's I believe the United States Patent and Trade, I want to say organization. Don't quote me on that, but I just know that the initials are USPTO. That's USPTO.gov. You can go on. I'll provide a link for that official site in this description of this episode. But unless you go to them to actually register your trademark or your company name as a trademark or brand, so to speak, you technically are only limited to the state that you're in to actually use your trademark without actually registering to the USPTO. So what does that mean? That means, let's say, for example, that myself, Charles, I basically started a company. Oh, I did. Danso Solutions. Now, if I actually didn't register my company as a trademark through the USPTO, technically I can only do business within the state that I am in right now, which is New Jersey. So that means that unless I register my trademark with the USPTO, I can't do business anywhere outside of the state that I reside in. That's very important for the audience listening. If you do not register your company through a trademark process through the USPTO, you cannot actually do business outside of the state that you're in. The reason why is because of the fact that the USPTO allows you to trademark your company, your brand, to use it on an actual domestic whole scale or globally, depending on how expansive you want to make your brand or business. So that basically means that they have to give you the okay to say that I can do business in New York, I can do business in Atlanta, I can do business all the way in California if I want to on the East Coast. And if I want to go overseas, that's a whole nother process of registering through them as well from an international trademark to do business outside the country. Now, you can say to yourself that I'm on the internet. Yes, I can do business, and I don't need the actual trademark registered. You technically can, but the only problem becomes come tax time when you're filing, and then your accountant sees that you actually didn't register your trademark through the USPTO, like I mentioned. You're liable to pay more taxes, even face a penalty as a result for doing business outside of the state that you reside in. So if you traveled, you're doing business, you moved, and your company is registered under the state of New Jersey, and let's say you moved to California, you never registered your business, you're doing business outside of in California, outside of New Jersey, you are liable to penalties under your business, as well as facing a heavy tax fine. Remember that. So in total, audience, make sure you register your company or trademark your company under the USPTO site officially. Again, I will provide a link for those that are interested in learning more about that. So again, let's continue. However, a registered trademark provides broader rights and protections as an unregistered one. I just mentioned that. Okay. So next, I want to get into what is the difference between the TM symbol, SM symbol, and the R symbol, circle symbol. What does that basically mean? I want to break this down for you guys. There is a difference. So what does that mean? Usually when you see a business name, you can tell a company is trademarked if in the actual filing they have a TM, SM, or an R circle to tell the difference between the three. So basically, let's start. Every time you use your trademark, you can use a symbol with it. That is true. Remember, if you have a business that's operating, technically it is trademarked. It's just not registered. It's not a registered trademark. Keywords, registered. Keywords, R, registered. That's going to be very important in a few minutes, guys. So every time you use your trademark, you can use a symbol with it. The symbol lets consumers and competitors know you're claiming your trademark as yours. You can use the TM for goods, the SM for services, even if you haven't filed an application to register your trademark. Once you register your trademark with us, that's the US, again, PTO, the USPTO. Then you can actually, you may use the registration symbol anywhere around the trademark, although most trademark owners use the symbol in a superscript or subscript manner to the right of your trademark. You may only use the registered R symbol with the trademark for the goods or services listed in the federal trademark registration. Let me repeat that again for those that may not understand what I just said. You may only use the registration symbol that is the R with a circle. If you guys are watching my video, I'm going to post that in this content for you guys to listen to, actually see visually. Again, the registered R symbol for the audience listening through the audio version is the only technically registered trademark symbol. If somebody has a TM, that just means that they have a business. That doesn't mean that it's actually a registered trademark that they have. It just means they have a business that's operating, and I hope they're successful, but that does not mean that they're registered. So what does that mean? That means that technically somebody can actually utilize their name, their color scheme, maybe their logo design scheme. Some people try to copy certain products or services of an individual if you're not registered with the R symbol. That's very important. So what am I trying to say? Register your trademark. I can't emphasize that enough, audience. At the United States Patent and Trademark Office. That is what the USPTO means. I fucked up earlier, so let me rephrase what I meant when I said the USPTO. That stands for the United States Patent and Trademark Office. That is www.uspto.gov. That is where you actually register your company through the trademark process to get approved. If you go anywhere else outside of an attorney and the USPTO, because the attorneys go to the USPTO, I hope everybody realizes that. They just make the process easier for you because they collect all the documents you need. They basically give their okay. They write their recommendations because they're attorneys, so they have the legal understanding. But it all goes to the USPTO. So in essence, if basically your trademark is not going through the USPTO and is going through some other entity, they're lying to you and they're just stealing your money. It has to go through the USPTO to get approved in order to have an actual registered trademark. Anywhere else is false. Remember that. Let's continue. So, again, having the R is very important. The TM just allows you, it basically just means you're doing business. So technically you have a trademark. You can also register your trademark using the SM symbol. The SM is a trademark symbol meaning a service company. So what does that mean? If you do a specific service, such as you build apps, such as you build websites, you build logos, you build products, certain products like beauty products, you build, let's say, official data sharing. Like that basically means how do you build stock calculations or something of that nature. You can register your trademark under the SM because what that tells others, including the government entity at the USPTO, is you are registering your trademark for an exclusive service that your company does. Again, that means if you have the SM symbol in the trademark process, that means that you're telling others that you are exclusively using it through a service-based business. And you can actually technically register your trademark under that. So that's very important. So kind of tying this all in, I gave you guys a lot of information, I know. Again, if you guys think I'm going too fast, if you guys are interested, for those that know me, hit me up directly. That's Charles in charge _1, or you can hit us up at Danso Solutions. I manage both pages, so I will get back to you as soon as possible on Instagram as well as Twitter. For those that may not know me listening, just email us at info@dansosolutions.com. That is info.danso solutions.com. Send the email. Myself or my colleague will get back to you in a timely manner. That's very important. So getting back to this trademarking. Why register your trademark? It is your choice whether you want to file or not. So again, I'm not putting a gun to anybody's head that may be listening or watching. It's just something that I want to share with you guys, bring it to light to understand that this is very important, especially if you have a business, thinking about starting a business. You do have to cover the legal component of your business. Protect yourself. Don't make yourself liable to predators. Even if you think that you're just starting out, nobody's really looking at me. You never know. People are sick like that in this world. People will try to take your ideas, take what you're trying to help better this world with. So just protect yourself. That's just a fuck you to them. It's your idea, it's your business. Protect your shit. Even if you got to spend bread, put up money, just do it. It's going to benefit you in the long run and save and be more cost effective in the long run as well. So you don't have to go through court cases to kind of make your claim to the judge or whatever the case is, or the lawyers that you may have to hire. Just get it done. Get it done early. The trademark process is backed up right now. I'll tell you that, because a lot of people during the pandemic have started business or thought about starting businesses. But get it done now, file now. The sooner you do it, for my business owners out there, those thinking about starting one very soon, the better that you'll get an answer or a response quicker. So why register your trademark? It is your choice, I mentioned. Trademark is listed in the USPTO database of registered and pending trademarks. This is what exclusively they're saying. This provides the USPTO public notice to anyone searching for similar trademarks. I just mentioned that. People will try to take your idea, name, logo, color, sound. That's very important. So again, just protect yourself the best you can. They will see your trademark, the goods and services on your registration, the date you applied for your trademark registration, and the date your trademark is registered. This is all shown on the USPTO website exclusively. Sometimes it may not show immediately. That does not mean that somebody isn't trademarked. Remember, like I said, the USPTO is dealing with a lot of filings. So if anybody sometimes is trying to get smart and think that just because you don't see their name there, that does not mean that they have not been approved for a trademark. If you do look in the weeks or maybe a month ahead, you will see the name populated. So that's very important to note. So again, it just kind of tying this all in, and I'm going to keep repeating it. Unless your trademark registration is shown or done through the United States Patent and Trademark Office, that is, or nicknamed the USPTO as their abbreviated term or name, so to speak, it's not a real trademark or registered trademark, excuse me. So remember, audience, and excuse me again, you have to register your company through the USPTO, which is the United States Patent and Trademark Office. That's very important. So again, just kind of going into federal, state, and international registration. How you choose to protect your trademark is really up to you. You are not required to register your trademark. I'm going to keep saying it. But where or whether you decide to register your trademark can determine the scope of your rights. Specifically, you can rely on common law rights or file for state, federal, and international trademark registration. So what does that basically mean? So again, each state has a process of filing. It all goes through the USPTO. So does international laws as well. If you are based out of the States and you have a business in London, many bigger businesses such as Amazon, such as maybe Apple. When they're actually going out of the country, they have to reapply for an additional trademark under the ones they already filed in the States to do business outside of the States in Europe, Asia, Africa, South America, and so forth. So that's very important to note. So if you are thinking about doing an international business or moving your business internationally, you will have to go back to the USPTO and file for an international trademark to do business outside of the state or country that you're in. So that's very important. So again, for the state trademark registration, just to kind of touch base for the audience, registering your trademark with the U.S. state creates rights in the state only. Remember, I said this. If you are going to do international trademark or do a business internationally, you need an international trademark filing. So if you're only doing a regular trademark, I will say, or state trademark through the USPTO, that is only good in the United States. You cannot do business internationally unless you file for an international trademark. Your trademark is not protected if you expand your business across state lines into another state where your trademark is not registered. If you decide to expand your business across state lines, you'll need to decide if you want to register your trademark in the state or apply for federal registration. Also, not all states have trademark registration databases. That's very important, which means that third parties will not be aware of your rights in your trademark. I kind of touched on this earlier. Like I said, sometimes you'll go on a USPTO and you may not see the company listed or the full rights of the company for the companies that are already listed on there. That does not mean that they're not protected through the USPTO. Sometimes it takes a while to update. Sometimes due to different state laws, you may not actually see the full description of the actual trademark based on the state that is maybe doing business out of, or maybe even the country. That's only because of a government entity. That may be the state laws that protect, or the international laws that protect that country or state. But that does not mean that they do not have the proper rights. So how can you actually find that out? You actually can look that up actually based on the type of filing that is done. Each trademark has a number that is filed under. And I kind of want to share quickly for the audience that's listening to exactly what type of trademarks numbers are actually used to basically do the filing. Most numbers for registered trademarks are from 1 through 99. And each one has different protections. Some have financial protection, some have merchandise protection, some have waste management protection, some have distribution protection, some have, again, just sound protection, color scheme protection. All these trademark numbers are basically protecting a specific type of service or type of product, type of entity that may be under your company. Each trademark number signifies what specifically that company is basically using their trademark for. So if you're using, let's say you're using trademark 25, that basically deals with clothing. So if you choose a trademark class 25, that deals with protecting like a merchandise type. So again, that allows you to basically print your logo on a t-shirt, and just, allow you to print logos on t-shirts, branding, where nobody can actually take your idea if put it on apparel. So what does that basically mean? If Nike is put in, Nike has a trademark classification 25, number 25. That means that the sneakers, the sweatpants, the hoodies, the hats, each product that they're pushing out, even the Jordans under the Nike brand, all of these are protected under class 25 of the trademark rights or laws, so to speak. So nobody can take it, a la example, Little Nas X, or do a similar product to the products Nike already has in place on their merchandise. So you cannot copy, you cannot embellish it, which basically means that you try to not exactly copy it, but it looks very similar. You can face a lawsuit and pay heavy fines because 9 out of 10 times it's going to be hard to win a court case against somebody that has filed a trademark classification for protecting their merchandise brand, logo, sound, example, all of that in one. So it's very important to know, audience listening, that just make sure that really do your research. My advice is, hey, we're all creative in different ways. Sometimes we need a little bit of a guide. Maybe we may need to look at something to do something our way. That doesn't necessarily mean we're copying, but that doesn't matter when you're in the courtroom. What matters is, how is your case going to weigh versus the other? How do you sway the jury or the judge or whoever is there, the prosecution, to show that your thing is legitimate? So just get the trademark rights protected the right way, so you don't have to go through all of that. Just protect it your way, do it the right way. Make sure that you do your research to make sure that maybe a service or a product that someone already has out that's protected, that you don't do the exact same thing and get yourself in trouble or have to pay a lot of money. Trust me, guys, from personal experience, it's not worth giving up more money than you need to. Save the money, use it the right way. That's what I recommend to those listening. So the last two topics I want to cover is, how long does a federal trademark registration last? And just make it a little fun at the end. I'll just give you guys some sounds I'm going to play on YouTube. If we have some ads, my apologies in advance. But I'm just going to play like two that actually are protected through the trademark brand that you guys may actually know or have heard before, whether you were younger or you hear it now, even in it may be through movies or just when you go out and you hear the sound. That actually is trademark and protected through the trademark registration through the USPTO and is covered by trademark law. So let's first discuss, how long does a federal trademark actually last once it's registered. Your trademark registration can actually last forever, long as you continue just to use your trademark in commerce and provide us with the USPTO with evidence that you're still using it. So how can they actually know that you're still using your trademark? Just have a business and make money. That's all it means. That means that if your business is operating, you have revenue coming in, you file taxes, you have employees underneath, you have people who contracted through the business. That all shows that you still have your business active. That means your trademark is still active. The only way that your trademark becomes dead is if there's no type of action. There's no revenue. There's no type of employees. You're literally just not working in your business altogether. You go on your website. There is no new event. You had an event August 2019, and it's 2021 going on 2022. You haven't updated your calendar on there, events, anything like that. Then your trademark becomes dead. That means that you expose your business, your brand, your merch, whatever the case is. So just make sure that if you are going to get a trademark filed, that you're doing your business, you're still active. And if not, then make sure that you just go in there realizing that you're going to be spending a good amount, maybe anywhere from $700 to $1,000 plus, just to get your trademark registered. So make sure that you do keep your business active, or if you keep your products or services active through your business. And if not, then walk away clean. Don't walk out of retirement and come back like Brett Favre, if you know football, or Michael Jordan. Make sure that you're actually retired and you have no regrets or anything if you are going to not do business anymore and try to refile your trademark. So that's important. So remember, trademarks last a lifetime as long as you use it. Trademarks are only legitimate through the USPTO, nowhere else. That's the United States Patent and Trademark Office. I'll have another, if you guys are interested, subscribe, comment on this episode if you're listening through YouTube, or just hit us up through the Danso Solutions or Danso Pitch podcast Instagram. and just let us know that if you want to hear about how copyrights work or patents work. I just wanted to make this episode exclusively for trademarks. So the next thing I'm going to talk about is just the sound of some trademarks that are actually protected. Now remember, if you hear an ad, my apologies. I'm doing this through YouTube kind of on the fly, so I'll try to skip it. Hopefully they don't run an ad. Like I said, they're running an ad, guys, so my apologies. I'm trying to skip this. Now, if you've watched any movie, guys, the Metro-Goldwyn-Mayer trademark. If you guys have ever seen a golden arch with a lion yelling every time a movie starts, that's MGM, the MGM lion. Any movie that you watch in the past or watch currently and you see a lion, pay attention to what's around the lion. You'll see the name Metro-Goldwyn-Mayer. Those are the owners of the MGM line. So basically, those are the people that are funding the movies that you're watching, or the studios that these actors and actresses and producers, screenwriters, or whatever the case is, are using these studios and getting the funding for these movies. A lot of times people don't realize that when you shoot movies, you need a budget. That means that if they're using all the explosions they do through these cities, they're using these states or countries, they get funded through a lot of these big executive studios, such as the Metro-Goldwyn-Mayer company. That's the lion that roars usually. I just played the sound for you guys. And there's two words that you'll see. It says Metro-Goldwyn-Mayer, and then you'll see trade on the left side of the line and mark. That's very important. That means that this sound specifically is protected through the USPTO. So nobody else can use that lion sound. Now, that may sound ridiculous because obviously lions roar in the jungle or in the zoo sometimes. So, I mean, it's like they're taking the sound of an actual animal. But they've used this for decades. This sound has become iconic before the start of movies. And they've made a profit because that they're able to reshare. And a lot of these directors have paid these companies such as Metro-Goldwyn-Mayer, like I mentioned, to use their studios. So for them to actually play the sound of the lion, they get paid every time you hear this sound. This company gets paid exclusively, and no one else can use this sound. That's some fucking beautiful shit. Gotta love business, guys. The last sound I want to play is this one that you guys may know. This is an iconic one that a lot of people have heard. If you've been watched any type of movie, any of the classic movies, I would say it's something that I would definitely just kind of check out. Now remember, this is something that I think is beautiful. This is something, again, my apologies for the ads, guys. I hate YouTube so much. But again, if you guys have watched Star Wars, if you guys have watched anything like that, if you've watched one of them older movies back in the days, you usually hear that type of sound. That's the Lucasfilm sound. That is something that you guys may probably already know or heard of. Again, that's trademarked as well. Just having one more fun with it. Let me just share this last piece with you guys as well. So you guys may have heard this sound if you've watched TV. Not this. So if you guys can actually hear for the audience through the video portion or the audio portion of this podcast. So those are NBC chimes. That is the sound itself. This sound itself is trademarked, and nobody else can use it. That's CNN, Fox, nobody else can use it. If they do use it, they will be sued and they will lose. In terms of Fox or CNN, and NBC will get a big payout, or anybody that tries to copy any of these sounds that I've utilized, other than the people that actually own it. Now you can go on the USPTO and actually see that a lot of these people actually own these sounds. So that's very important to know, guys, for the audience that's listening. So in all, I hope that you guys were able to take kind of what I said today and just kind of utilize it for yourself. I think that, you know, it's protect your business as best as possible. Like I said, it's tough already for us being business owners, being service individuals, building products for our business or through our business or through a business partner. So just protect yourself. Don't waste more money than you need to. Don't put money up more than you need to. I'll say that instead. You know, the most important thing is you have something that's yours. Your business is your baby. Protect it the best as possible. You know, make the right decisions, even if you feel like it's hurting your pockets early on. Just get it done early so you don't have to suffer in the future by trying to have to battle it out through court cases or wherever the case is. The point of a trademark is you have legal protection of your brand, business, services, entities overall. So that's very important, guys. So in closing, guys, enjoy. This is the last week. Probably I'm going on vacation next week, but I will be back hopefully with a guest for you guys. I'm trying to see if I can get an actual attorney for a future trademark episode where we can actually discuss copyrights and patents as well. Excuse me. That is in the future update that I'll send you guys exclusively through the Danso Pitch, as well as Danso Solutions Instagram as well, which is the main entity of the Danso Pitch podcast. So check us out again. This is the Danso Pitch episode 47. I'll just do it. That's another piece that's trademark. Business tags. Just do it as Nike. They have that slogan protected as well as trademark under their name. So this is episode 47. Just do it. Protecting your business through the trademarking. So that's very important, guys. I'm gonna take y'all out. Enjoy your summer. Let's talk soon, guys.
Do you have an idea for an invention or new product?
I gotta change this up, by the way.
Eager to get started.